Hi, this is Brad Wiewel, and we are here doing a video to go through for you the changes that we're going to be making this year to your estate plan that you've created through our law firm. You are a LifePlanning client, which means that you're part of our annual updating process, and this is your third year in our cycle. And this is the year you're going to get all new stuff from us, and we have got a lot of new great things we're going to provide for you, and all these things are necessary, important, and appropriate. Before I get to the changes, I want to talk about a few things that are going to be happening that you need to be aware of, because we want to get you as much information as we possibly can so you know what to expect, you know what you're going to receive, and you're going to know how to act upon it. One of the things you're going to receive from us is this little booklet, and this booklet will have all the changes that we're making this year to your documents described inside this little booklet. You'll get this little booklet, and we probably could have written it in bigger type, but we didn't. So when you get it, grab your glasses and take your time, but it's very informative. You'll like reading it. We wrote it in such a way you certainly won't need to be a lawyer to understand it, but look to get this from us. And by the time you watch this video, you should have already received it from us. This is something else that you will receive from us. This is very, very important, as all these things are, but this is especially important. This is a request for name changes, address changes, cell number changes. These are things that we need from you so that if a loved one, a child, your sister, your brother, your cousin, who may be a medical helper, a financial helper, whatever, has changed their location, and that information, we need this from you, and we need this from you completed 1 week prior to your updating meeting. Please. This will help your updating meeting go quicker, smoother, as will watching this video. So if you watch this video and you understand the concepts and you take your time to read our booklet, your time at our office for the update meeting should be shortened by at least half hour, maybe even an hour. Now, we know you love coming to see us, and we certainly don't mind seeing you, but nobody wants to linger on this topic too long. So if you fill this out and you read the booklet, then you should be in good shape to spend as little time as you may want to at our office to get this update meeting done. But we're not going to be in any hurry. We will never be in any hurry. So fill this out. Now, there's a carrot and a stick with this form. If you fill it out and you return it within 1 week of your meeting, then you get entered into our raffle. And this raffle has been an extraordinarily popular thing in our office. We're starting our 4th year on a raffle. So if you're a client who's updated 3 years ago, you know about this raffle. If you're a client who became a client in the last 3 years, you may not know about it, but this raffle is, again, extraordinarily popular. If you get this form in a week prior to your scheduled meeting, we put you in the raffle, and in January of 2023, we'll draw a name out, and the person or couple who won the raffle will get a year's worth of life planning for free, which, as you know, is a nice little thing. So if you want to try to get a year's worth free, fill this out, send it in, we'll put you in the raffle, and we've done it 3 years in a row, and it's nice to call people and say you won the raffle, and this year's on us. So please do that. Another thing you'll find in your packet will be this pink sheet. This is a summary of your values. We need to know how much you're worth, and ideally what categories your assets fall into. There were lots and lots of rumors in 2021 about changes to estate taxes. They didn't come true. We don't know what the future holds, nor do you. So having this information in your file will help us to better help you plan for an unknown future and unknown future tax changes too. So please bring this with you to your meeting, or send it in when you send in the yellow sheet too. Okay, let's get cracking. Let's talk about the things that you're going to find at your meeting, and the things that we're making changes to, the things that are going to be outlined in your booklet. And We strive mightily, it may not always seem like it on your side of the table, but we strive mightily to make all this gobbledygook as simple as possible. In fact, we've got a new little motto in our firm that we make the complex simple. And one of the things we're going to give you this year is a trust information form. And this is a one-pager that will have the name of your trust, who the trustees are, the date of the trust. You can use this to give to a financial advisor if you're at the bank or some other place opening an account, or you're online. This page will have virtually everything you're going to need to open an account or to talk to somebody about your account fairly cogently. Now, always if there's a question on your part or their part, feel free to contact your funding coordinator, who will be happy to help you. And we take calls from clients all day long, but this should shorten your time with a financial institution and make it easier for you. And we're, again, all into making it easier for you. Along with that, we have a little thumb drive. Now, you have a blue thumb drive in your binder. It reminds you the blue thumb drive is a copy of all the scanned documents that we've done for you. So in your binder, every document you signed, witnessed, notarized, whatever, is on a blue thumb drive. This new white thumb drive is a trustee training class that I have created and taped for your family so they can watch it and be better knowledgeable, be better aware of what they need to do if something happens to you. It's about a 23-minute long video. It's not obtuse, it's not complex either. But we want to do everything we can to get to your family information they need to know to take care of you and take care of your estate if you're unable to take care of it yourself. This will also be in the middle ring of your binder next to the blue thumb drive, again with a copy of all your documents on it. So something we're trying to do. We also do family meetings, remember that. So the loved ones you've got that you want to do a family meeting with, we do it at 3:30 on Friday afternoons. Those family meetings take 1 hour. And we don't go into how much you're worth or where the money is. We do say you've got a trust. Here's how it works. These are your responsibilities. It's a great meeting. So 3:30, any given Friday, please let us know and contact your funding coordinator and they'll get that scheduled too. All right. Question we get all the time, well, what do I do with my digital accounts? And we got a couple things we're going to talk about today about digital accounts. But one of the things about digital accounts that's kind of frustrating is who knows where they are, who knows what your usernames are, who knows what your passwords are. So we have this tool, and you probably have seen this tool if you've been around it for a while. This is where you can list usernames and passwords. We don't want a copy of this tool. We recommend you keep the tool in your binder because we're really not worried about somebody burglarizing your home and taking a 6-8 pound binder with them, and you can't fence it. So it's a pretty good place to keep this, but somebody needs to know where this is. A big change we made now is on that blue flash drive you've got, this will be in a fillable format. So you don't have to handwrite it on there. You can use whatever software you use to type right onto the form so your family knows what your passwords and usernames are, because without that information, it can be extraordinarily complex and expensive in trying to find out what those are, if we can find out what those are. All right, so this is critical, and this, again, will be in your packet. Another thing people like is they like our summary, trust summary. Here's your trust summary. I'm sure you sit around most evenings and open that big binder and flip through the 100 pages of the trust and kind of, isn't this interesting, honey? Of course you don't. We normally have to kind of brush the dust off the binder when people come in for their update meetings because nobody's really looked at that binder since we gave it to you when you walked out of our office. So we don't anticipate you're going to read it, but you might read a summary. So again, we're trying to make this easier for you, clearer for you, and this is about a 9-10 page summary of the most important parts of your trust. This will be toward the front of your trust binder. Please read it. If you have helpmates that you want to make sure understand it better, this is a wonderful thing that you can email them. This will be on your blue thumb drive too. All right? Download it, email it to them. But it's simple, and again, we're trying to make the complex simple. A large part of the focus of our practice, unlike, frankly, most other estate plan lawyers, is not on death, it's on incapacity. It's on taking care of you when you can't take care of yourself. And frankly, the way I say it is, if I'm your lawyer, my job is to take care of you. And I'm a whole lot less concerned about your other loved ones. We're going to take great care of them, of course, but we got to take care of you first. This has been in the front of your binder, and it said what to do when a family member dies. And it's a great little summary of what to do when a family member dies, but we didn't have on here what to do when a family member is approaching incapacity. Now we do, all right? We've added 3 things. Contact us on the first signs of symptoms of dementia or Alzheimer's. Locate the documents, and make sure there's good umbrella insurance in the car and at home, because surprisingly, we have clients who are getting a little wobbly but don't think they want to give up their driver's license yet, and could create a horrific liability problem for the estate. So please make sure when somebody's in that situation, they've got plenty of umbrella liability policy to cover an unforeseen, unknown, and unfortunate accident that can happen too. So this will be at the very front of the binder. Somebody opens the cover of the binder, this will be there. When the flash drive is open, this is the first thing someone's going to see. And on the back, to remind you, is information about how to avoid having someone, an elderly person or a deceased loved one, having their identity stolen, because that happens all the time too. All right? So let's get into the changes. I'm not going to spend a lot of time on each of these because they're highlighted in the booklet, and the longer this video, the less likely you are to watch it. So I want to make sure you watch it. So I'm going to keep it crisp and clean and focused. So here we go. One of the things you've added to your trust is a statement of love and affection. Those trusts are big, they're important, they're critical, but they're not very loving, and they certainly aren't affectionate. So we've added a paragraph that says at the very first page, look, I know this is a sterile, legal document, but to remind you, I love you. And thanks for being a part of my life. Just a little kiss on the cheek, pat on the head, hug, whatever, to let the family know that you do love them, you did love them, and to go forth. Homestead rights. So one of the wonderful things about Texas is if you get sued, they can't take your house. We have added homestead protections. There was a new legal case that came out. We've taken the language from that court case, we've added it to your trust, and we've added provisions so that if your children or a child or another loved one inherit your house, they'll have those similar protections too. Enhanced ability of healthy spouse to adjust the trust during incapacity. So probably 70% of our life planning clients are married, and about 30% of our life planning clients are single. If you're a married person, then the likelihood is one of the spouses is going to become incapacitated before they die and before the other one becomes incapacitated or dies. And in the past, the trust was kind of locked down. You couldn't make changes because you both signed it, and we don't want one of you running off and making changes to give it to another person, for instance. So we are allowing the healthy spouse to make changes to other smaller things in your trust, maybe even some tax provisions, but nothing that would allow them to give off the estate to another person, another spouse, for instance. So we've added some flexibility, but we're not throwing out the baby with the bathwater. We have changed provisions regarding when a trustee is in fact incapacitated and when they need to be removed, not so much you, but again, a successor trustee, because we don't want somebody who is your trustee to be managing your money when they're impaired, for goodness sake. So we've added provisions to make that process clearer. we have, maybe your favorite part, maybe my favorite part of this whole thing is if I am incapacitated, well, what if I get better? Do I get control back? And the answer is yes, you do. And you always would have, but we made that section clearer too and simpler too. So if I'm better and I'm ready to get the financial reins back, I can much simpler and more effectively. All right. It's a very popular change, by the way. Simplify the administration for a beneficiary serving as trustee. Again, we want to make this simple on your loved ones too. I'm sure each and every person that you've got involved in this is a smart person, because you wouldn't have put them on there if they weren't. But on the other hand, making things simpler for them is a goal that you probably have and we probably have, so we've done some things to make that happen better. We've strengthened provisions regarding corporate trustees. Now, the vast bulk of our clients don't have corporate trustees. Some do. We may have a corporate trustee in waiting for you, which means we don't have one name, but heck, if all the people you have on your list can't do it because they caught COVID and died, well, maybe we have to get a corporate trustee, and we have added provisions to make sure we're picking a financially solvent corporate trustee and not just somebody or a company that might be a little less expensive. We want to make sure they've got the grit and the resources to do their work, but also if they screw it up, the family can be reimbursed from their screw-ups. We have added provisions if somebody takes you into their home to care for you, then home improvements can be made to their home to make it more comfortable for you and for them. And we've added a section on bill paying, because bill paying is, again, something everybody does. But if you can't do it, somebody's going to do it for you. And a lot of times, of course, the people that you have backing you up are busy people too, and you're going to generate a lot of bills. So this provision allows your trustee, your helper, to hire a bill paying service that they'll monitor and all that, so it'll take some of the load off of them. And bill paying services are very common now, so it's just something that we've included in yours, again, to make it easier for the folks who are going to try to help you. Clarification of restoration, I talked about that. Long-term care benefits for veterans. Quite a few of our clients are veterans and retired military and served in the military, which we all appreciate. And they're entitled to veterans benefits. And so we've crafted the trust to make it easier for them to access veterans benefits if those are available. Pet provisions. We have 2 dogs, and we have lots of clients who have pets. We have some clients who don't have pets, don't want pets. I'm not sure where you fall in all that, but if you are a pet lover, then we have enhanced our pet care provisions and made it easier for the trustee to place your pet with a family friend or a care facility that will care for them in the best possible way. So Fluffy and Fido will be better off because of these new provisions than they would have been before. We've expanded 2 things regarding our special needs beneficiaries. We have a large number of clients that have special needs beneficiaries. They are people that may be suffering from autism or Downs, or perhaps an accident that left them mentally impaired. And this first one is if they're on Medicaid and they inherit tangible personal property. So this thumb drive, this little device here is an example of tangible personal property. It's affected by gravity, so jewelry and firearms and pens and all that are tangible property. And in Texas, a special need person can inherit that, and it doesn't affect their qualifications, the amount of assets they can have, but in some states it does. And heck, Texas may change its rules. So we've now said if a special needs person is in line to inherit tangible property, then, and it would screw up their benefits, then we're not going to give it to them, because their benefits are more valuable than any, frankly, trinket they might inherit from somebody else. And that would be a disaster. They lost their benefits. I'll get to the second point here in a minute. We have done some other things with tangible personal property. When it comes to estate taxes, adding up the value of tangible personal property, that's included in the value of your estate. Now, again, most people don't have hundreds and hundreds of thousands of dollars of tangible personal property, but we've added a few things to your trust. One big thing to minimize the amount of tax we might have to pay on tangible personal property. Allowances for beneficiaries during post-death administration. So these things, when you're gone, administering your trust, quite frankly, takes time, and quite frankly, will take money. But you may have somebody in your family, let's say a kid in college or a younger child, for instance, or somebody who's dependent upon you at some level that needs money now and can't wait for all the wheels of a trust administration to finish before they get access to money that may be thrown out of their dorm or whatever. Your trust now allows the trustee to distribute money right away to somebody who is on the beneficiary list who needs it right away. So we've just made it easier to do that and taken away any risk or fear that they're not going to have access to the money you left them until some of this legal stuff has occurred. Increased flexibility for surviving spouse to provide for children. So your children are very, very precious to you. If you have children, then again, back to having children and back to single married clients, probably 70% of our clients have children and 30% don't. If you're in the 70% that does, then of course you want to make sure your children are well protected. And we've added provisions to allow that to happen better, but we've also put a cap on it. And we normally say once kids are 26, if you're still alive, then they need to move off the dole because we may need the rest of the money to take care of you. It also minimizes a chance of conflict, and it minimizes a chance of a contest, because sometimes we have dealt with rogue children and the rogue child wants money now, but they're not supposed to get it till later. This minimizes the challenge from the rogue child as well. Some of our clients have accounts in what are called payable death accounts and transfer on death accounts. These are accounts that are in their name. They don't want to put the account in the name of their trust. They can keep it in their name, but if you die with it in your name, you're going to create a probate. So you can do something called a payable on death, where it stays in your name, and when you die, it flips into the trust. With a securities account, stocks and bonds, you can keep it in your name and do a transfer on death, where it flips in to the trust. And we've added language that if you want to do that, we don't recommend it, but if you want to do that, here's how to word the payable on death or the transfer on death so it actually ends up in the trust. And again, it doesn't cause a probate, which is something we're trying desperately to avoid for you. Minimize risk of a rogue beneficiary disrupting the survivor's tranquility. We're typically not that worried about your kids, but many of our clients have blended families. And so if you're in a blended family, we're always concerned about a stepchild, and they may be the most wonderful people in the world. But again, a stereotypic stepchild may decide to challenge one of the surviving spouse over some issue and demand that you give them an accounting. And they may have the right to demand an accounting, but they don't get an accounting more than once a year. If there is harassment, we have built in some provisions to require them to pay for whatever they're asking for and really try to find some ways to back them down and make them more, easier to live with than they might otherwise be. We have a philosophy of death. The vast bulk of our clients are leaving their kids their assets, their loved ones their assets, protected from a divorce and from a lawsuit and from a bankruptcy. And this philosophy of death says, hey, we've done this for you. Keep the money in this trust. I mean, you can spend it, you can invest it, but if you pull it out, it's not protected from those things. If you leave it in, it is. So leave it in. If you have questions, call the Wiewel Law Firm. And by the way, we're changing our name to Texas Trust Law. That's a new thing. You'll get more information on that here soon. But call us, and we're happy to walk them through what they need to do. But it's important it's important that they keep it in the trust, if at all possible, to have those protections. The Secure Act, holy cow. The Secure Act was a huge change in the law they made at the very beginning, January 1st of 2020, that really changes how people inherit your retirement accounts. It doesn't affect spouses, it doesn't affect you, but it affects, again, anybody other than your spouse and a charity who may inherit your retirement account. And everybody's going to have to pull the money out of the retirement account in 10 years unless. And there are 2 or 3 unlesses. And one of the unlesses is they have a chronic illness. And maybe between the day we've signed this and your death, one of your loved ones develop a chronic illness. Maybe the day we sign it, they've got a chronic illness. Well, the person with a chronic illness can take it over a much longer period of time. Minors can take it over a much longer period of time. We've got little things like that. So your trust now has what I call a Swiss Army knife approach to the Secure Act. When you pass away, we can look at the beneficiaries and we can craft it for that one beneficiary to make sure that beneficiary gets as good a deal as the law lets them have, and as good a deal to minimize taxes and maximize the amount of money that they can withdraw from your retirement accounts. Increased education for special needs beneficiaries. Again, back to special needs. Before we were talking about tangible personal property. If they inherit too much, it might disqualify them for their benefits. So the trust says they can't. We've had educational opportunities for our for our special needs beneficiaries. Now we've laid language about therapies, educational opportunities, camps and things like that we didn't have before. And now we have those provisions as well, so give them as full a life as possible. We have protection for trustees who happen to be professionals. So one of the things that we do here is we do try to protect the people that you picked to be your successor trustees, because they're doing it by and large out of the goodness of their heart. There's someone who, it may be, again, a child, a family member, a friend who you need them to help, and they're willing to help, but they don't want to put their own financial assets at great risk, and we've got a lot of protection for them, frankly, built into your trust, so they aren't held to as high a standard as a corporate trustee might. We also have language that if the family doesn't go with a corporate trustee and they go with a lawyer or a CPA, the lawyer and CPA is held to that much higher standard too. We've added something in your trust to say, except if you pick your kid who happens to be a CPA or a lawyer and they're managing your trust, they're not held to the same high standard that a corporate trustee would be held to. They're held to the same standard as anybody else would be, despite the fact they may also be a lawyer or a CPA. We don't want to put them at greater risk of getting sued or whatever than anybody else who you might pick to be your trustee. Hope this makes sense. All right. We have reinforced the trust from challenges. So we live in a litigious world, and you can't go down the freeway without seeing lots of plaintiffs' lawyer billboards. And so we have added a few things to your trust to make someone who might be thinking about trying to bust your trust to back them down, to have them think extra hard about it, because these new provisions will make them think much earlier and harder about whether they want to or not. And of course, you don't want them to, and we don't want them to. And again, we want them to really give much more consideration to the risks of challenging, trying to break your trust than not. This is your plan, not anybody else's, and we want to make sure it stands up to the course of time. So we've added some things to try to do that better. Courts don't like those clauses, but if we do it right, it should help. Just about done, by the way. We have clients that own small businesses. The small business is taxed as a S Corp, which is a special way to be taxed by the IRS. We've enhanced provisions to allow that to happen smoother and cleaner. This is interesting. There is a new law in Texas that allows trust to continue. Used to be about 80, 90 years. Now a trust can continue for 300 years. Now, I know, I'm not sure you'll be seeing me in 300 years, at least on this side of the grass, but some people have built into their trust generation skipping provisions and things like that, where the money stays in the family. Well, if it stays in the family, going forward, it can stay in the family for 300 years. So we've added some stuff on that, as crazy as it sounds, but we live in interesting times, and that's the new law, so we can do some of that for some folks. We get calls all the time. It's probably one of the most frequent things we get calls on. People read an article or talk to somebody and, hey, who's your digital executor? Who's your digital trustee? Is the agent on your power of attorney the digital agent? And the answer is yes, yes, and yes. So whoever's your trustee in your trust will say they're our digital trustee. Whoever's the executor in that little will you get will say they're the digital executor. The digital agent on your power of attorney is the digital agent. So if somebody at some institution wants to see it in writing, we've got it in writing for you to give to them too. And we're giving you a new power of attorney. Power of attorney is used in a trust setting really pretty much only to manage things that aren't in the trust, and particularly IRAs, 401ks. So you're getting a brand new super duper financial power of attorney from us this time too. And last but not least, and I'll wrap up on this, this whole experience is about death and dying. And one of the things that we don't want to have happen is for conflict to occur over your funeral plans. And I just had this in my family a year ago. And we worked it all out, thank goodness, but boy, we have added massively to the section on memorial instructions. The memorial instruction tab is the third to last tab in your binder. We have really beefed that up. The more instructions you can give, the more decisions you have made, then the fewer decisions anybody else has to make, and the fewer the chances of conflict. We also recommend our clients do pre-planning, do your pre-funeral planning. Cindy and I have done ours. We're going to be cremated, have her ashes buried up by her parents in Salado, and we are currently awaiting the arrival of her headstone. Now, you talk about fun. Go buy your headstone some week, and that'll perk things up, right? Anyway, do a lot of that. Get that done so people know it's all paid for. They don't have to fret about it. They don't have to fumble around it. Who's going to pay for this freaking thing? Who's going to advance the funds for that too? It's already paid for, so please do that too. Okay. I'm going to stop here and say thanks for being our clients. We will see you in the office. Please watch this video carefully. Bring your questions to your update meeting. We're happy to answer all those then. Look forward to seeing you, and drive carefully. Thanks.